Good evening, class. This will be a continuation of our lecture on the law on contracts. We will be discussing tonight Chapter 4, Reformation of Instrument. So let's begin with the definition of reformation. So reformation in 1359 is a remedy in equity. Remember, it is the means by which a written instrument is made or construed so as to express or to conform to the real intention of the parties, when because of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. So remember, in reformation, yung written instrument ay binabago and it is made to conform to the real intention of the parties. Kasi yung instrument, iba doon sa pinag-usapan ng mga parties. Naging iba siya because of mistake, fraud, inequitable conduct, or accident. And remember again that yung written instrument or the instrument as drafted fails to express the real agreement of the parties. So, in reformation, hindi binabago yung contract or yung agreement. Ang binabago lang is yung written instrument. So, kung ano pa rin yung napag-usapan, yun pa rin yun. Pero ang pinapalitan lamang ay yung nakasulat na instrumento. Kasi yung nakasulat na instrumento ay mali or iba doon sa tunay nilang pinag-usapan. Dahil nga doon sa mistake, fraud, inequitable conduct, or accident, mali yung naging resulta or pagkakadraft noong instrument. So remember, in an action for reformation, which obviously you file in court, the courts will not attempt to make another contract for the parties. But remember here, kasi may agreement na sila may contract na sila. Hindi na sinusubukan ng korte na baguhin yung contract na yon. Kasi yun ang napag-usapan They have to stick to whatever the agreement is. But remember here, what the courts will do is to inquire into the intention of the parties and reform the instrument, not the content. So, yung agreement hindi nila babaguhin, pero ibabaguhin lang nila dyan yung nakasulat na instrumento. So that the instrument will express the real intention, the real agreement of the parties. So, yun ang tandaan natin sa reformation of instrument. This is not reformation of contracts. Iba yun. What we reform here is the written instrument. The written instrument. So, anyway, the requisites for an action for reformation, remember, there is already meeting of the minds of the parties to the contract. May napag-usapan na sila. Meron ng meeting of minds, there is consent, may offer, may acceptance, yung etc. ang lahat ng discuss ko sa section 2. Kompleto na yan. Kompleto na ang rekado ng contract, ng agreement. But remember here, class, that the true intention or agreement of the parties is not expressed in the written instrument. So, yung sinulat nilang instrument, yung naka-type, naka-computerize, etc., it does not conform to the real agreement of the parties. What else? The failure to express the true intention is again due to fraud, mistake, inequitable conduct, or accident. And remember, the facts upon which relief by way of reformation of the instrument is sought are put in issue in the pleadings. So, ang hirap ng pagkakasabi, no? Pero ang gusto lang sabihin dito is that ilagay nyo dun sa inyong petition or complaint pala, yung inyong initial pleading for reformation, yung basis for reformation of the instrument. So, you allege in the pleadings kung bakit nyo pinapareform yung instrument. Yan. At saka kung ano yung totoong agreement, ilagay nyo doon. So, what else? In addition to that, there must be clear and convincing proof of the mistake, fraud, inequitable conduct, or accident. What else? It must be brought within the proper prescriptive period of 10 years. Hindi lahat ng libro nilalagay yung prescriptive period. So remember, 10 years. What else? The document must not refer to a simple, unconditional donation inter vivos. to a last will and testament or to a contract where the real agreement is void. So also remember, in Reformation, documentary and oral evidence may be admitted to prove yung intention of the parties. So anyway, please take a look at your book regarding the difference between Reformation and also annulment. So anyway, in a nutshell, in annulment, this is the remedy when there is no meeting of minds. So wala pa talagang pinagkasunduan because there is vitiated consent. So there is defective consent on the part of one of the parties. So sa totoo lang, wala talagang meeting of minds. So yun ang remedy kung talagang merong vitiated consent and there is no true meeting of minds. In Reformation, kung meron na talagang meeting of minds, true meeting of minds, remember, but the instrument does not conform to the agreement, that is your proper remedy, Reformation. So anyway, Reformation is proper in the following instances, which we will discuss one by one later on. In case of 1361, there is mutual mistake. 1362, mistake on one side and fraud or inequitable conduct on the other side. 1363, there is concealment of mistake by the other party. 1364, there is ignorance, lack of skill, negligence, or bad faith on the part of a third person. And at 1365, there is a mortgage or pledge stated as a sale. Also include there 1346 in case of relatively simulated contracts. Remember, relatively simulated contracts, ang binding dito is the real agreement of the parties unless yung agreement as drafted, the agreement as drafted will control if it prejudices third persons and if the real agreement is contrary to Lamog PP. So anyway, kakadiscuss ko lang yan sa simulation in chapter 2. So anyway, in 1346, relatively simulated instruments which do not prejudice third persons and it is not contrary to Lamog PP, yun lamang ang pwedeng i-reform to the true agreement of the parties. So kung there is prejudice on the part of a third person and it is contrary to Lamog PP, yung real agreement, hindi yan kasama sa pwedeng i-reform. So anyway, also remember, sa complaint siya. Complaint for reformation, the plaintiff must allege that the instrument to be reformed does not conform to the real agreement or intention of the parties, and it must also allege yung kung ano yung real agreement or real intention of the parties. So please take note also of 1360 in case of conflict between the provisions of the new civil code, which is not really new at all, tanda na ng law na to, and the principles of general law on reformation, the former will prevail. Supplementary effect lang yung general laws on reformation. So anyway, in 1361, we will talk about mutual mistake. So remember, the mistake is mutual, meaning it is both parties who are mistaken. And remember, yung failure of the instrument to express the true intention of the parties is because of the mistake of both of them. Dalawa silang may kasalanan, which is why the instrument does not express their real intention. So I think the example in your book, let me just take a look if there is an example. Wala pala. Ay hindi, meron. Pero anyway, let us say class, seller is selling to buyer a house. The buyer agrees to buy a house. So anyway, they drafted an instrument. So, itong mismong bahay na to ang tinutukoy nila. They agreed on the same house. Sinignan pa nila. So, yung kanilang intention is the same. To buy this particular house na yun ang binibili ni buyer, yun din ang binibenta ni seller. So, true agreement. Yan, meron na tayong true agreement. Now, in the instrument, dahil nakalimutan nila yung bahay, or they are not aware of the number of the house. So, let us say, nilagay nila is number 18. Yun ang nilagay nilang bahay, number ng bahay. Number 18, Road 7, Barangay San Vicente Hills, Tarlac City. Ganon ang address. So, anyway, but later on, they learned na yung palang house number is not number 18, but number 12, let us say. So, anyway, the mistake is on the part of both parties. They erroneously believe that the number of the house is number 18 when it is in fact when it is a fact that the number of the house is actually number 12. So here, the remedy of the parties is reformation. So both parties can ask for reformation because here the mistake is mutual. So anyway, it requires that the mistake must be a mistake of fact, and it is proved by clear and convincing evidence. Obviously, the mistake here is mutual mistake. Yan. So, anyway, in 1362, ito na pala yung requisites. So, mistake of fact, clear and convincing evidence, mutual mistake, and the mistake must cause the failure of the instrument to express the true intention of the parties. How about 1362? There is mistake on one side, isa lang ang nagkamali, and the other acted fraudulently. Yan. Nanloko yung isa, nagkamali yung isa. So here, mistake is not mutual, but unilateral. And the other party, one party acted fraudulently or inequitably, and the other act mistakenly. So there is mistake committed by one. So here, the right to ask reformation is granted to the innocent party or the party who was mistaken because the mistake here is not mutual mistake. So let us say class, debtor manghihiram siya ng pera kay creditor. Ang hinihiram niya is 10,000. Tapos itong si creditor drafted a promissory note. Sinulat ni creditor sa promissory note, imbis na 10,000, 1 million. So, anyway, itong isa, hindi niya napansin, pinirmahan niya. So, anyway, here, one acted on mistake. So, one committed a mistake in signing the instrument, and the other acted fraudulently kasi nilagay niya 1 million instead of 10,000. So, here, class, mistake on one side, fraud or inequitable conduct on the other side. So here, class, the true agreement is that debtor borrowed only 10,000 pesos, but the instrument does not express the true agreement of the parties, and the instrument expressed that the debt of the debtor is 1 million. So here, reformation is available as a remedy to the debtor only, because the debtor is the party mistaken. Mistake is not mutual. Debtor is innocent. So, person who acted by mistake may ask for reformation of the instrument. So, remember here, class, after meeting of minds, one of the parties acted fraudulently. So, meron na sila talagang real agreement, may meeting of the minds, but one of them acted fraudulently. What else? In 1363, there is concealment of mistake by the other party. Again, here, mistake is unilateral, but the other party is guilty of concealment. Again, this is fraud by concealment. Alam mo na ngang mali yung pinipirmahan niya, hinayaan mo pa siya. One party is aware that the instrument does not express the true agreement of the parties. So, here, yung isa, alam na nga niyang mali yung pinipirmahan, hindi pa niya pinakorek, hindi pa niya sinabi, hindi siya nagsalita. So, that is fraud by concealment. So, again, the remedy of reformation is available to the party who acted in good faith or the party who is mistaken. Yeah. The party who, tama naman, the party who concealed the mistake cannot avail of reformation because the concealment here constitutes fraud. So, yung pwede lang mag-avail ng reformation is the innocent party, the one who acted in good faith. What else? In 1364, remember, there is ignorance, yan, lack of skill. There is negligence or bad faith on the part of a third person who drafted the instrument. So, here, a third person may drafts the instrument. So, and the instrument failed to, again, represent the true intention of the parties. So, probably, clerk, typist, secretary, etc., etc., sila yung nagkamali dito. So, it is not a mistake on the part of both parties. So, because neither is responsible for the mistake, both of them can ask for reformation. So, either of them. So, pwede din both, malamang. So, anyway, the court here may order the reformation of the instrument if the instrument does not convey the true intention of the parties because of, again, ignorance, lack of skill, or bad faith of the drafter of the instrument or clerk or typist. So, let us say, class, again, promissory note, 10,000 pesos. Yun ang nakalagay yun ang true agreement. Debtor is indebted to creditor 10,000 pesos. Pero, syempre, itong secretary, siya yung nag-draft ng promissory note, secretary ni attorney, ayan. Kaya mahirap mag-secretary Minsan mali-mali yung pinatype, tapos pipirmahan mo yun. Ikaw naman, pangalan, as lawyer, lumilitaw yung pangalan mo doon. So, tapos, wrong grammar pa, kakahiya. So, anyway, ano ba yan? 10,000 pesos. Yan ang agreement of the parties, creditor and debtor. Debtor will borrow 10,000 from creditor. Secretary drafts the promissory note, and the secretary, through negligence, placed yung amount as $10,000. Nilagay niya imbis na peso sign, nilagay niya dollar sign. So anyway, here, class, remember, the intention of the parties is clear. There is a real agreement, 10,000 pesos ang uutangin. But because of negligence on the part of the third person, who is in our example the secretary, the instrument may be reformed so that it will express the real intention of the parties. Because in the instrument, $10,000, pero real intention of the parties, 10,000 pesos. Either party may ask for reformation. Pero, alam nyo, kung parties are willing to draft a new instrument and sign it, di nyo na kailangan pumunta sa court. Mas mahal pang pumunta sa court para lang sa reformation na yan, if both parties are amenable to correct. Diba? So anyway, bakit pa pupunta sa court? So, 1365, there is a mortgage or pledge stated as a sale. So remember here, reformation of the instrument is proper. Otherwise, true intention of the parties would be frustrated. So, ang gusto talaga ng debtor dito is to secure the debt only. Isa-secure lang niya yung payment ng debt niya through the mortgage or pledge of property. So, magmo-mortgage lang siya ng lupa in real estate mortgage, or magmo-mortgage lang siya ng personal property as in a chattel mortgage, or mag-pledge siya ng personal property also. So anyway, but yung instrument as they have signed it is not a contract of mortgage but a sale. So obviously, yung intention ng parties dito is frustrated because of the instrument. So again, remedy is reformation. So intention of the parties can be adjudged from their contemporaneous and subsequent acts. Tingnan nyo kung ano yung kinikilos nila after contemporaneous, kasabay, and also after the instrument is drafted and signed by the parties. What else? Kanina sinabi ko that reformation is not allowed in some cases. So number 1, in case of a simple donation inter vivos, where it is not conditional. So unconditional donations during the lifetime of the donor. Inter vivos is during the lifetime, no? Mortis causa is after the death, effective after death of the testator. But donations inter vivos effective during the lifetime of the donor, and it is not conditional. Remember, unconditional. Remember, it is not subject to reformation, because essentially gratuitous act, and donee has no cause for, binibigyan na nga lang siya, magko-complain pa siya, di ba? So donor is not bound to correct mistakes or defects in the donation na hindi naman talaga niya kailangang ibigay. Kumbaga, nagmamagandang loob na lang siya, hindi naman niya kailangang magbigay. So anyway, donor can ask for reformation of the deed of donation if the donor wants. Anyway, sa kanya naman nakasalalay yan kasi siya nga yung nagbibigay. So and pwede naman ask ka pa ng reformation, just draft another one, pahirapan pa yung gusto So anyway, what else? If the donation, remember, is conditional or onerous, the deed of donation may be reformed so that the true conditions imposed by the donor or the real intention of the parties might be expressed in the instrument. So conditional donation, ibibigay itong lupa na to pero kailangan magtayo ng eskwelahan. Yun ang mga onerous donations So kung mayroong mistake at some point doon sa instrument, it can be reformed. So halimbawa, magtatayo ng school, yun ang condition sa donation, pero ang totoong ang nakalagay sa instrument, magtatayo ng commercial building. So this can be reformed based on the intention of they have to prove the intention of the parties in making the donation and also in accepting yung donation. So anyway, wills cannot be reformed. Siyempre, di ba? Ito nga yung wish ng namatay Tapos to take effect after his death. So personal and free act, and obviously upon the death of the testator, the right to reformation is lost. Tapos yun na nga, because this is purely voluntary on the part of the testator, or yung gumagawa ng last will, testator ang tawag sa kanila, huwag mong kakalimutan. He may revoke yung kanyang last will at any time before his death. So in case of death also, errors, imperfection in descriptions may be corrected in under 789 if that is the case. Pero remember, yung pwedeng i-correct dito is simple errors or imperfections in descriptions lang, but not the manner of property disposal. So yung imperfect description means no person or property exactly answers to the description, and in the context of the will and based from extrinsic evidence, pwede siyang ma-correct. Remember class na yun lang ang pwedeng i-correct, errors, imperfection in descriptions, but not the manner of property disposal. So yun ang, syempre, will nang namatay yan, no? Di ba kayo kinikilabutan sa ginagawa nyo? Gusto nyo pang ipa-reform yung manner of disposal? So mas mabuti nang bawal i-reform. So what else? Agreement is void. If the real agreement is void, there's nothing to reform, because again, like sinabi ko dati, technically an agreement which is void is technically non-existent. Nothing to reform. What else? When one party has brought an action to enforce the instrument under 1367. So remember here, this is based on the doctrine of estoppel or the doctrine of ratification. Remember in estoppel, kung ano na yung na-establish ng parties through words or actions, and another person has relied on this misrepresentation, remember, hindi na pwedeng i-deny yan, because one party has relied, a third person has relied on this misrepresentation. So anyway, in ratification, it cleanses a contract of its defects from the beginning. So when a party brings an action to enforce the instrument, remember, nagkakaroon siya ng admission ng validity of the instrument, and also he admits that the instrument expresses the true intention of the parties. So if you want to bring an action for reformation, this is inconsistent with an action to enforce yung instrument. So anyway, an example in your book, there is no example in your book, but anyway, let us say seller sells a house to buyer, seller drafts an instrument, but the instrument, instead of being a contract of sale, the seller drafts a contract of mortgage. So lumalabas na parang itong si buyer, sinanglan lang niya yung itong si seller, sinangla lang niya yung kanyang lupa kay buyer. Para nga naman pwede niyang tubusin, di ba? So anyway, yun ang ginawa ni seller. Seller drafts an instrument, but the instrument drafted by the seller is a mortgage contract instead of a sale. So anyway, both parties signed the contract. So here, the buyer believed all along that the contract is a contract of a sale. And here, seller acted fraudulently. Kasi ang draft niya na instrument is not a contract of sale, but a mortgage contract. So yun ang facts. So anyway, itong si buyer, upon knowledge of the mistake in the instrument, may bring actually an action for reformation. Kasi nga, remember, there is mistake on the part of one party, and there is fraudulent conduct on the part of the other party, who is the seller in this case. Mistake on the part of the buyer, fraud on the part of the seller. But if the buyer here files an action to foreclose yung mortgage, gusto niya nang irimata yung mortgage, or let us say, sinisingil niya yung utang ni seller, na lumalabas na isang debtor dun sa mortgage contract. Because remember, a mortgage contract also, meron ding contract of loan yan. Kasi accessory contract nga lang ang mortgage, di ba? So, hindi ka pwedeng magsangla nang wala kang inuutang. So, obviously, nangutang ka. So, if the buyer here / creditor, yan, dun sa instrument as drafted, enforces the instrument by, let us say, demanding payment, or number 2, foreclosing the mortgage. So, itong si seller / creditor in the drafted instrument enforces yung instrument which was mistakenly drafted, fraudulently drafted pala in our example. So, here, if buyer enforces the instrument, he cannot ask for reformation kasi binibigyan bisa na nga niya yung mortgage Kaya nga naniningil siya at saka gusto niyang rematahin yung lupa. Tapos bigla ipapareform pa niya. 'Di ba? Ang gulo. So, action of buyer / creditor is inconsistent with reformation. So, anyway, yun ang example sa number 4 or letter D. So, also take note of the parties entitled to reformation if either of the parties, in case of mutual mistake, in case both of them are mistaken. So 13, 61, 64, and 65. In all other cases, party who is injured or the party who is innocent, yan, under 13, 62, 63, 64, and 65. Heirs or successors in interest, in lieu of the party entitled. So, kung namatay na yung party who is entitled to bring an action for reformation, heirs or successors in interest. So, 1369, procedure for reformation. Sabi, rules of court will govern procedure, pero wala pa ring rules na pinopromulgate. Basic kasi ang ating mga ang ating Supreme Court sa kakagawa ng maraming ibang bagay. So anyway, burden of proof, remember, is on the party who insists that the contract should be reformed. So in short, ang magpapatunay ng true intention of the parties is yung party who wants to reform the instrument. So there is kasi a presumption that the instrument expresses the real agreement of the party. So, presumption na yan. Kailangang i-overcome ng party who wants to reform the instrument yung presumption na yon by presenting, obviously, contrary evidence and proving the real intention of the parties if there is another intention, obviously. So, again, also, take note that the effect of reformation is retroactive from the time of the execution of the original contract. So it will go back to the time of execution of the real agreement, not from the time that the contract is reformed by not the time from the when the instrument is reformed by the court. So yun ang tandaan natin sa reformation of instrument. So anyway, that's it for reformation class. Thank you and good night.